So as you know perfectly, the growth in the use of digital asset is gaining popularity. This so-called crypto winter is probably escalating the popularity of digital asset, but even more is attracting the attention from lawmakers and regulators from different perspectives. The idea of this panel is first to talk about the issues related to enforcement in digital asset. That is the second part of a project of ELI, a project that started with a first deliverable consisted on a set of rules and guiding principles related to the use of digital asset as collateral in the context of secure transaction. And this second part is going to be focused on enforcement on digital asset. As digital assets are attracting attention from regulators and other international organizations, this panel is going to cover as well how other organizations, in particular UNIDROIT, is dealing with, on the one hand, the private law aspect related regarding digital asset, and on the other hand, to which extent the general rules and best practices on effective enforcement require any specificity in order to be effectively applied when we are talking about digital asset. In order to cover all these different angles and to have enough time for what I hope will be a fruitful discussion with all of you, we are going to organize the panel as follows. I'm going to give the floor to the different speakers in the order that I will explain in a minute. They're going to have between 8 and 10 minutes in order to present the different, as I tell you, for dimension or angles that we are going to take into consideration. And then we will open a Q&A session with all of you. I'm going to give the floor first to Chef Van Erp. I'm going just to introduce the speakers in a very, very quick way, so please don't hesitate to read a more long and elaborate and detailed curriculum that you can find in the brochure of the annual conference. So as you know very well, Chef Van Erp is an emeritus professor of civil law and European private law at Maastricht University, and in relation to this topic, he is the co-reporter of the ELI project on digital asset enforcement. So please, Chef, if you are ready, please, I give you the floor in order to explain the outline of the project, the ongoing project of the ELI. Please, Chef.
Thank you, Teresa. Thank you very, very much. Those of you who entered the room may have seen that already we, as panelists, were in quite some discussion. So we hope that we can have that discussion with you. Just a few more general words. Already Teresa explained how the project began. In fact, it began very general as access to digital assets many years ago, when this problem was completely new. But then we began to realize that the whole idea of access is far more complicated. Should it be control? But then what means control? What do you mean by access? Does access include control? What is it? Digital assets. What sort of digital assets are there? How do you define them? So what we now do is talk about a specific problem, so not just about access to digital assets generally, but about enforcement against digital assets. And we will focus on private law. But I must say, those of you who were here at during the previous session on e-evidence in criminal proceedings, you will hear quite a lot of the same problems occurring in private law that is occurring in criminal law, in criminal procedure, when it comes to e-evidence gathering. There, the question was, did the public prosecutor have the power, the jurisdiction to ask for access outside his or her country, and so on. That's the same sort of problem we will encounter here. That guidance is needed. I can tell you from a recent case that I still didn't read, I just read the summary because it was really recent, of the criminal chamber of the Netherlands Supreme Court about the question whether the police could seize an Instagram account. The answer was no, the police cannot, because an Instagram account is nothing. In more technical terms, the Instagram account was not a physical object, and we can all agree with that. But it's also not a patrimonial right. So it's not a right. Is that the correct approach? What does this mean? You could say, well, this is a a decision by the criminal chamber, but it's the criminal chamber of the Supreme Court. What does this mean? So I think guidance here is needed, and the ELI can play a very prominent role here. Now, what we do in the principle, that's basically the structure, is that we follow enforcement the way it develops over time. And that is based on the work that I was involved in, and also my co-reporter, Jos Uiterhaag, within the framework of the International Union of Judicial Enforcement Officers, where we drafted a global code on enforcement against digital assets. What we discovered, discussing it, is that from the perspective of actual enforcement, so the approach was not academic, it was practical, based on actual practice and actual problems. The problem number one is tracing the assets, how to find them. And there we have in Europe several differing systems. In some countries, the judicial enforcement officer is like a private detective. You have to search for the debtor's assets. In other countries, the debtor can be called into court and must under oath declare what the debtor's assets are. So there you have already differing systems, differing approaches. So we have tracing. And how can a judicial enforcement officer trace digital assets in another country than the country in which he or she has jurisdiction? So how to do that? Should that be regulated? For the moment, this is based on cooperation. I've heard that, for instance, a judicial enforcement officer in the Netherlands might call the colleague in Belgium and say, we have the idea that the debtor has particular assets in Belgium stored in a cloud server there. Can you help us? So it's now cooperation. So tracing. Then the actual seizure. How do you seize a Bitcoin? Well, it has to surface somewhere, sometime. So you seize it where it surfaces. But when you talk about other digital assets, like social media accounts, and here the problem, if an Instagram account is nothing, there is nothing to seize. Which might mean that in certain cases, a debtor can have a digital asset with considerable economic value that no one can touch. Is that what we want? So seizure. Then we have the actual enforcement. So if there is a judgment or in the civil law system an authentic deed allowing enforcement, how to do that? And there we have examples that the enforcement can take place in digital format. So an internet auction. These are already happening. For instance, in the United States, when the US federal government seizes Bitcoins, these Bitcoins are auctioned through internet. The same is happening in France. So we have digital enforcement against a digital asset. These are the problems we encounter. And of course, they raise problems of private international law, competence of the judicial enforcement officer, competence of the court, recognition of judgments, recognition of competence, and so on. They also raise more substantive questions. And basically, I think the outcome of this project will be the drafting of principles of a fairly general nature that can act as what a private international lawyer would call a règle d'application immédiate. So irrespective of the applicable law, this is the principle that applies. So if, for instance, enforcement is done through smart contracts, there should be supervision of a human being as a general rule, whatever the law applicable. So basically, I think, Teresa, I described the project, described the steps that will be taken, described some of the problems, and I'm looking forward to the debate.
Thank you very much, Chef, for explaining so clearly and even succinct the outline of the project, the main aim and the main problem that has been detected. Before giving the floor to Luis, let me just try to anticipate some of the problems that we have to discuss, and we have been part of the debate. As you can see, the concept of digital asset. To which extent we need a concept of digital asset, to which extent this concept should be broad in order, for example, to include a social profile or social account as well, or we are just talking about cryptocurrencies, crypto token, NFTs. So as you can see, a conceptual level of discussion is fundamental. There are also another point, if I may just raise the point that we have been discussing before, Luis. Are we talking about problems related to factual aspects? Is a factual problem, Luis? Or is a legal problem? We really need new law, new legal rules? Or is just a problem related to how we materialize, we put in practice the law? Are we talking about problems related to digital assets per se? Or they are related to effective enforcement? So probably, Luis, I would like to give you the floor. Luis Gallifer, she is a Rice Bowl Professor of English Law at the University of Cambridge. And in particular, among many other merits of all the speakers that I have the pleasure to be with in this panel, she is the chair of the drafting committee at UniDRA in relation to the project on digital asset and private law. So Luis, please, the floor is yours.
Thank you very much indeed. I have a PowerPoint. I hope
It's ready.
Yes, it's already there. Can you see the...
I can see it, but can everybody see it?
Yes, it's going to be in a minute. Let me see. Probably require a second.
Not that I mind, because it doesn't say anything important at the moment, but I would like it to be there eventually, if you see
No podemos verlo en las pantallas grandes. In a minute. I can see that in Blackboard.
Well, okay, so anyway.
No, it's okay. It's there.
It's okay, right. So the first thing, that's just a disclaimer to say that we still have a work in progress. And that's actually quite important because we are nowhere near finished this project, although we are a bit further on, quite a lot further on, I think, than the ELI project on this particular point, at least. And in fact, in UniDRA, there are two projects. And I'm only here to talk about one, really. The other, so there's a general project on best practices for effective enforcement, and that's looking at all types of enforcement and relating to all types of assets and other matters to do with enforcement. I'm not really the right person to talk about this. There are two people in the room who know a lot more about it than I do. One of them is Teresa herself, who is on the working group, and the other is Anna Veneziana, who is here, and I'm sure will be able to fill in anything that I miss about that particular project. You'll hear what I'm going to say about it in a minute. The one that I am involved in is a project on the private law of digital assets. So it's not just about enforcement, it's about aspects of private law that are considered that we need to or may need to be changed in relation to digital assets as opposed to law that is already there. And the project has defined digital assets relatively narrowly, and I get the impression, and I can stand corrected, that the ELI project is going to be quite a lot wider. So the way we have defined a digital asset is an electronic record capable of control. Control being that it's possible that a person has the exclusive ability to change control and the exclusive ability to exclude others from the benefit of that asset, as well as the ability to get benefit from that asset. And I don't want to take too long on this because it would get very complicated, but the idea is that the core is something like Bitcoin. In other words, it is an electronic record on the blockchain or some other similar system that has the same characteristics, which is controlled by a mechanism. At the moment, we talk about the private key, public key mechanism, and whoever has the private key is able to be controlled by someone. If there's only one person with the private key, then they will have exclusive control. This, therefore, relates largely to what loosely are termed cryptocurrencies. It also relates, and I don't want to say too much about this either, to the digital asset side of what we would call a linked asset. So these digital assets can be linked to other things. They could be linked to debt securities, for example. They can purport to be linked to tangibles, though it's very difficult to see how that can be done without legislation. They can purport to be linked to shares. They can purport to be linked, again, very difficult, to some kind of IP right, and so on. So when you hear about tokenized securities or NFTs or whatever, the way we look at it, that's a digital asset that is linked to something else, and the link is either there or it's not there. It depends on what we call other law. So the way that we've done our project is to develop principles consisting partly of specific rules where we consider those are necessary to reduce legal uncertainty in relation to digital assets. And we don't have that many of those. We also have supporting legal analysis for those rules, such as the definition of digital assets, such as the definition of control, which I've already outlined to you. And then we have principles which say, actually, lots of aspects are left up to what we call other law, and that is law that doesn't fall within those rules within our principles. And we have quite a lot of analysis as to what is left up to other law, and a lot of commentary saying other law may say this, may say that, and it may deal with, so for example, linked assets, and we give examples of how other law may enable a debt security to be linked to a digital asset, but may not enable a share, an equity security, to be linked to a digital asset without legislation, because shares need to be registered on a company register, which can't be comprised of digital assets without legislation. So that's the sort of structure of the principles. It's, if you like, although they're only principles, minimum harmonization. We're just looking at the rules and the aspects which we think are necessary to deal with digital assets. Now, what I thought might be useful is, rather than tell you everything about the project, because we'd be here all night, to give you a few thoughts. We've had some thoughts about how much we need to put into the project on digital assets about enforcement. And we've been discussing this last week, so it's very fresh in my mind. And what I've given you here, I'm going to give you some thoughts based on that discussion from the perspective of the working group I'm involved in. We are going to continue talking to the effective enforcement working group, and this is more or less what I was talking to Chef about, which is that there are often going to be best practices in effective enforcement which will enable digital assets to be the subject of effective enforcement, but they are not, in my view, specifically about digital assets, and not at least at the degree of generality that we are going to talk about it in our group. Now, just one thought, perhaps helpful, perhaps not, certainly something we talked about, and that is what enforcement is. So we think that enforcement is really enforcement where there has been some kind of default or some kind of breach. We're talking about private law here. So, for example, both extrajudicial and judicial enforcement of security interests. Execution of judgments. I think that was, Jeff mentioned that, where you've got a judgment against another party, you want to enforce against their assets, and they have some digital assets. Judicial orders, post-judgment, judicial orders, pre-judgment, interim judicial orders, freezing orders, that kind of thing. And possibly, and I think this is covered in your project, I'm not sure, but the position on insolvency of one or more parties. If a party becomes insolvent, you know, how is the estate distributed, and so on. Now, we've also, this is a couple of examples, what is not enforcement. So a contract performed by self-executing code, which is, in my view, a better way of describing a smart contract. So a smart contract is self-executing code. It's not a contract, it's just a piece of code that enables things to happen on certain triggers. It can be part of a contract. You can have a contractual obligation which is performed in that way. That is not what we would call enforcement. That is performance of an obligation under a contract. Similarly, and this is just the same thing, but in rather more specifically, where you have a transfer of a digital asset which takes place automatically, but is not triggered by a default. So the idea of for example, MakerDAO. We had a long discussion about MakerDAO. MakerDAO, roughly speaking, is where assets which have been transferred fall below a certain level, then they are automatically transferred back to the transferee and a transferor. And that is not really enforcement, that's just saying when something happens, these assets will come back. So we're not really thinking about that as enforcement. And I should say that although we thought intellectually security interests could be the subject of automatic enforcement, when we actually put the feet of our technical experts to the fire, they were unable, last week anyway, to come up with any convincing examples of real security interests at the moment which are automatically enforced by smart contracts or anything else. That doesn't mean to say it won't exist, but it meant that it was quite difficult to work out what we needed to say about them because we had no concrete examples. And then I suggest, though, that in order to talk about enforcement, you need certain private rules and analysis. And I think Chef would agree with me there that, you know, you're building on your private law. And so our project deals with these types of things. So to give you an example, we have a principle that says digital assets can be the subject of proprietary rights and security rights. Digital assets as we define them. That, of course, then feeds into the enforcement rules because you are enforcing something in which there is a proprietary right, and so on. You can see a few more of them there. We have one principle that says proprietary rights in digital assets are effective again on insolvency, for example. So I think that our principles feed into enforcement in that way, but that's not really enforcement, that's the precursor to enforcement that you need in order to build your enforcement rules. Now, this is where we possibly differ, but at the degree of generality that we're operating and the type of digital assets we're talking about, it seemed to us there are probably very few new private law rules required which relate specifically to enforcement against digital assets as opposed to other assets. It's not to say that there aren't rules which would make enforcement against digital assets easier or better, it's just that they would also, in certain circumstances, make enforcement against other assets easier or better. And that way, they may fall within your project, they may fall within Anna's project, but they don't fall within our project. So I'm not, we're not really making a general statement. We're just saying that you have to be very careful that when you're thinking just about digital assets, that there don't seem to be many rules which actually only are useful in relation to digital assets. We have discussed some examples. If I have time, and I'm hoping somebody's timing me because I'm not, I'll discuss those at the end. But this is the point that Teresa mentioned, and it seems to us this is the case, that in many cases the difficulty is either evidential or factual. It is applying existing rules to the digital assets situation. You don't want to change the existing rules, you just want to think about how they apply and what are the best ways of structuring both transactions and the enforcement rules to apply to digital assets. And the generality that we are operating in our digital assets project in UNIDROIT, don't forget this is global and not just EU, means that really we can't say anything useful in our principles. We are going to say, I hope, something useful in the commentary to explain how enforcement rules could be effectively applied to digital assets. So it seems to us that what we need is good general enforcement rules, and I know it sounds a bit buck-passing, but that really is for the effective enforcement group to think about, and not us. Therefore, Anna and Teresa, and they might want to say something. And what we're going to focus on is commentary. Now, I can either stop there, or I can just give you one or two examples. I don't know what would be useful.
A minute, Louise.
I have a minute, right. I can talk very fast, but you won't like it. I'll give you one specific example. This is a little bit complicated and may not even make sense to many of you. And it came from one of our experts. We have a rule in the principles to complement the definition of control. And that is we realize that if someone alleges that they have control of a digital asset, and therefore a consequence flows from that in a piece of litigation, it might be very difficult for them to prove that they have an exclusive ability. And I should say, by the way, that the abilities we're talking about are factual abilities. They're not, there's nothing to do with legal rights. It's factual abilities to control this asset. And to prove that you have something that is exclusive is almost proving a negative, because it's to prove nobody else has that ability, and that is very difficult. So we have included a presumption that if somebody proves that they have all the abilities, those are presumed to be exclusive unless proved otherwise. And that was done from the point of view of someone, as it were, claiming a digital asset by saying, I have control over it. Now, what was pointed out was that in the enforcement situation, you might need the reverse, which is because in the reverse situation, you'll have an enforcement officer saying, you have factual control to whoever it is. And they would also have to prove a negative unless you have some kind of rule. So the idea would be to sort of extend that rule backwards, if you see what I mean, so that if someone proves that another person has the factual abilities, those are presumed to be exclusive unless they can prove otherwise. And so we haven't done it yet because this only discussed last week, but that's the sort of rule we were thinking of including. And that is very digital asset specific, and it also relates to our rest of our principles, which is why we think we should have it. So those are the sorts of things we were thinking about. But I think that there's more to be said on general enforcement. Thank you.
Thank you, Louise, very much. So from the perspective of the digital asset, this idea of general principle of applicability seems to suffice. From the perspective of the effective enforcement, we discussed that later, if you wish, in the Q&A session. Are these challenges related to location of a digital asset a problem requiring a specific legal rule, or simply a specific best practices enhancing or ensuring the enforceability and the effective enforcement of a digital asset? Is the difficulties of tracing a problem that required a specific legal approach? Do we have problem, for instance, related to identification of the debtor holding the digital asset that required a specific attention? Or, for instance, do we have in the existing procedural rules a mechanism to force the debtor to provide or reveal the private key or the recovery phrased in a way that is effective for the purpose of digital asset universe? So this is the kind of question that definitely required some discussion. But as you can see, we have different angles, and there is an angle that is clearly related to digital asset as assets that are essentially data-based. There is privacy and data protection. And that is why the next speaker, Daria Ruterska, you are going precisely to talk about that perspective, data and privacy. Daria, she's senior associate in Schonreher.
That's correct, yes.
In the technology and digitalization group. So please, Daria,
that's
the floor is
correct.
yours.
I will just go for the clicker.
Yes, excellent. Oh, sorry, you are going to remain seated?
I can stand.
Okay, lovely.
I hope you can hear me clearly. So thank you for the introduction, and good afternoon, ladies and gentlemen. As said, being an IP and data protection lawyer, my interest sort of naturally gravitated towards the data privacy and IP issues, and that means that they gravitated towards social media profiles as digital assets. And as much as I agree that Instagram can be nothing, I don't think that the same can be true for the content that is published there and for the money that goes behind it. So I would like to get back for a second to the definition of a digital asset. I hope I will do it.
Say, click again.
Oh, perfect. So a digital asset is something that is stored exclusively electronically, digitally, and it is something that is of some value. It doesn't matter what kind of value it may be, as long as it can be traced for money. The digital asset has three main points which must be present in order for something to be considered an asset. First, it must be electronic. Second, it has to be subject to right of control or enjoyment or any kind of use, regardless of whether that asset represents something of a real world, something that exists, for example, a work of art, or whether it is digital in its nature. And thirdly, the digital asset must be capable of being transferred from one party to another, whether it is via contract or by any other means, by voluntary disposition. The social media as digital asset. Of course, one may argue whether social media profile has all of those characteristics of a digital asset, but as already mentioned, I took the liberty of copying a part of the previous work of the working group. Social media and other online accounts can have measurable value, of course, especially when they belong or when the account holder is a person of public interest or a celebrity or any other person or entity that has any kind of value, personal brand, which brings money, of course. And whether that person or entity can contribute or disseminate some kind of information about a product, whether any kind of content, artistic content, or any other kinds of copyrighted materials are published on a given Instagram or any other account. I'm using Instagram as an example from our previous speaker. So social media profiles, they exist exclusively online. They exist exclusively digitally and electronically. They, of course, may have a huge value, monetary value, and they are subject of some kind of control and especially use, of course. Now, the things that drew my attention with respect to social media profiles as assets are, one of them is the right to access that account and that digital asset, so to say. Because it, of course, depends on the given terms of use of a specific platform. Let's stay on Instagram. And as far as I'm concerned, as far as I know, Instagram does not allow for automatic transfer of an account from one holder to another, and Instagram must give its consent for such transfer, basically. So this poses a lot of questions in case of enforcement of social media profile as a digital asset. For example, in case of death of the account holder, what happens then? We have a question of transfer of the social media profile. How can it be done? Whether we need an agreement, whether Instagram should be a part of this agreement or any social media provider. And of course, what can be done? Instagram or any other social media accounts is not only the access to the account per se, but most of it is the content that is being published, the content that in most cases is copyrighted and in most cases has some artistic or any other value. Now, how are we going to protect it against potential risks in case of enforcement, in case of transfer of that digital asset from one party to another, to the enforcement body? Because the potential risks, of course, include data breaches, cyber attacks, and any other cybersecurity issues that may and most probably will occur in similar situations. So, coming back to the intellectual property-related issue, I am a Polish lawyer, so of course I work basically based on Polish law, and let me tell you, the idea of fields of exploitation, which may not be known to many other jurisdictions out there, is something very difficult under Polish law, because without specifying explicitly what fields of use may be given in a license or in a transfer agreement, the transfer of IP may simply not be valid and effective. So what happens in case of enforcement of a digital asset? How can we register, or how can we actually specify which fields of use are present in our case? Because in Poland, at least in Poland, I will be happy to hear how it is in other countries, but at least in Poland, we cannot say that everything with the digital asset can be simply done. We have to specify what exactly can be done with the digital asset itself, whether it is a photo or whether it is a text which is copyrighted, whatever it may be. Now, the second issue that I find quite interesting in the area is the processing of of personal data and legal grounds of such data processing. Of course, we have consent, we have execution of a contract, legitimate interest, etc. We have everything listed in this simple slide. But what kind of legal ground can be used in case of enforcement? Whether it is a protection of vital interests of someone, of data subject, of any other entity. I am not sure how far in the project this will be considered, but I think it is a crucial issue to have one simple ground of data processing, because consent, as much as it is good one, it can be withdrawn. So we cannot rely on consent itself. There must be something else. Legitimate interest, it is fine, in my opinion, but we need to have a balancing test, whether the interests of the data controller override the interests of data subject, which is crucial, and it's very difficult in many cases to carry out simply. Now, I would like to sum up the main issues, because the local restrictions that may apply may ruin the entire enforcement procedure. I mean, we have restrictions, for example, in Poland, of course, we have restrictions regarding types of data which can be processed. It may happen that, let's say, employer provides NFTs to its employees and then gathers some data about each and every employee it has, and it participates in the program. And then such NFTs may be seized or may be a subject of any other enforcement proceedings. And the enforcement body wants personal data from the employer. What the employer can do? In Poland, there is a specific list of employee data employers are allowed to process without any consent and without any other additional legal ground. What happens here? Should we enter into additional agreement with employer first in order to be able to seize the digital asset that is NFT? That's not clear at the moment, and I think the interest should be given to that particular area. Second issue are the mentioned fields of exploitation, which are crucial under Polish law, and of course, we also have to think what exactly can and what should be considered a digital asset in case of social media profile, especially taking into account the very recent fine imposed on Instagram of over 400 million euros, if I remember correctly. The decision is yet to read for me. It has not been published yet. But the issue at hand was about processing data of kids, of minors. And it was about their email accounts and phone numbers that were being processed by the Instagram holder and generally by Meta. The fine seems quite big. And what can happen if we, for example, have a social media profile account that has pictures of our kids? And what happens if that picture is an advertisement for something and as such has some value because it is a digital asset in itself? It brings money to the account holder. This is very, very important question. And the last one are potential restrictions regarding the mere enforcement in a given jurisdiction. For instance, we need to check whether in specified jurisdiction, whether there is anything that can restrict our enforcement with respect to digital assets. For example, in Poland, if we treat the social media profile or any other digital asset as an intellectual property, there are many restrictions. One of which is that as long as economic copyright belongs to the creator of the given work, they should not be seized. They should not be enforced. Of course, there are some exceptions to this rule. I'm not a procedural lawyer, but this exists. So we need to check in every jurisdiction, regardless any potential restrictions that may apply with respect to digital assets enforcement. And that is it from me for the time being. Thank you very much.
Daria, thank you very much. Yes. So definitely, depending on the concept of digital asset that is finally adopted by each project, this kind of data privacy or IP issues are going to be more or less present, more or less pressing and challenging, depending precisely of the scope of this category of digital asset. Now we are going to conclude the panel taking in the experience of the judicial officer. What kind of problems, what is the experience of the judicial officer, what kind of challenges you see when you are in front of the enforcement related or regarding digital asset. In order to do that, we have Dovilė Tsatkauskienė. She is the director of the Chamber of Judicial Officers in Lithuania and General Secretary of the European Union of Judicial Officers. So please, the floor is yours.
Thank you very much. Good afternoon. Thank you for the invitation and the possibility to share our Lithuanian practice. And I am fully practitioner, and we who would like to sell Facebook profile or LinkedIn profile. And if to be honest, after such presentation from the lawyer, we are a little bit concerned. And in Lithuania, we have electronic auctions almost 7 years, fully electronic auctions. And I can confirm fully that we have never sold any profile. Yes, we were selling rights to have a rent agreement, rights to some other kind of property, but never sold digital asset. And after such comprehensive possibility to make a lot of complaints, we must be very careful, and why we are very waiting for the report of the project, of the ELI project, and we need very much these guidelines. And replying to the other speakers, we need not only guidelines, but of course adaptation of law and new regulations, technical regulations, and other regulations for valuation of such kind of assets and so on. So I would come to my presentation and would like to say that, of course, we see that digitalization does not leave any country aside. And therefore, debt recovery from these digital assets must be as global as the development of virtual currencies. And judicial officers in Lithuania are trying to intervene into modern money transactions technologies so that the debtor cannot hide anymore and cannot be, as we call sometimes, phantom debtor. And what has already been done in Lithuania. We are trying to do enforcement from small part of the property. It's electronic money and transactions with electronical money. And from 2015 in Lithuania, the seizures of bank accounts all electronically. And of course, this guarantees fast and efficient recovery of the debt. But we went further and we created a centralized monetary restriction system. And in this system is integrated data of 18 different institutions. And these institutions are from one side financial institutions like classical banks, and from other side judicial officer, bailiff. But when we are talking about financial institutions, we keep in mind that we connected to this system also institutions providing financial services to the clients, like online payment platforms and end-to-end integrated payment solutions, payment apps like Revolut. And we know that Revolut payment platform was launched in UK and is used worldwide and make more than 100 million payments per month. And we also connected a Paysera. It's also paying platform used widely in Austria, Germany, Spain, and other European countries. And such possibilities, of course, make enforcement more faster. And how it works. System is working online, and judicial officer usually will send request for the attachment to the bank directly, but in Lithuania he will do this via this e-system. And the system, according to the information collected and predefined algorithms, will form the unified order of the writing of money from the debtor's account. And when I say unified, it means that that system checks itself how much requirements are coming from different system users and different creditors, and the system counts by itself, determines the requirement amounts which must be drawn and transfers to the judicial officer's account. So in such size, such small part, the debtor cannot be longer in shadow, in gray side. And of course, if the debtor, for example, carries out some financial transactions, the system, how to say, feels this such debtor's activity and autonomously initiates the restriction, limitation of the monetary funds in the debtor's account. And of course, this is less chances for our debtor to be a phantom debtor, as I mentioned before. But as I mentioned, it is only a small part of property to which recovery could be directed. And we feel the clear lack of enforcement measures, for example, blockchain databases. If a decision is made through the arbitration in regards to the blockchain and that decision is not carried out in good faith, then who can help to enforce it? And when the judicial officer is outside of blockchain, so how to enforce such decision? And for example, cancellations of digital transactions, so far there's no technical ways to return digital money to its original location. And I can erase many problems like identification of seized digital property. If the debtor, for example, has bitcoins in an electronic wallet or mobile phone, how can judicial officer get the private key to do any enforcement action with the aforementioned bitcoins? So far, legislators are yet not to regulate these issues accordingly. So it's very important to devise and propose mechanisms that would force the debtor either disclose the necessary information or to impose appropriate sanctions for the non-disclosure. And this can be arise some other problems like valuation. Okay, in the end of this procedure, enforcement procedure, we find bitcoins, but it's not clear how to take them and where to archive them, and what price of seized bitcoin could be during selling of these bitcoins. Can judicial officer have his special wallet, for example, to take these bitcoins and to put them in this wallet? And this valuation of this property can change in few minutes. Just Elon Musk is coming to Twitter and putting any message, so the valuation of the bitcoins will go down very fastly. So of course, we understand that before this widely use of digital assets in enforcement and some criteria and requirements must be established to ensure respect for the fundamental human rights. And we think that harmonization of digital recovery will be one of the key topics for the legal society during few next years. And would like to emphasize that such projects like initiated by ELI, like access to digital assets, will be at the forefront. And I can just wish strength for the project group, and we are very waiting for guidelines, and later we hope for the regulation in European Union level also. So thank you very much.
Thank you, Davila, very much. Let me just open the discussion immediately, and in order to do that, let me just summarize some of the challenging issues that we have been discussing today. First, as you can see, the concept of digital asset from a broad to a narrow concept, to which extent the idea of control plays a role in the conceptualization of digital asset, controllable digital asset, controllable electronic transferable record, or going beyond that. Second, as you can see, the problems related to legal categorization, if I may use that word. So the legal status, to which extent they are subject to proprietary rights, for example, and could be part of collateral in a security agreement. Let's go in more detail aspect related to enforcement, location. Is location relevant for the purpose of defining applicable law, defining jurisdiction, but also defining the competence of judicial officer? And second, what means location in the case of digital asset? Where this information is, or where the private key, that is at the end, what we really need for the purpose of transferring or accessing to the digital asset. So we have the problem of location. Do we need a custodian? Do we need a third-party provider? Is the same to have a hot wallet or a cold wallet? Can we apply the same rules? Do we need to make a distinction in the two different scenarios? The problem of valuation. Are there really a well-functioning market that the judicial officer can use for the purpose of to sell in a very competitive and effective way bitcoins, crypto asset, NFTs, or a social account? Is there really a market for that? How to enforce? Do we need a specific enforcement mechanism, or we can use the one that we have? For example, we can use a garnishment or a attachment order exactly as we do when we have a bank account. So this is, in my opinion, a very broad summary of what kind of issues might be part of the debate, requiring legal rules, requiring interpretation, or requiring best practices from a more factual point of view, as you were referring, Luis, in your presentation. So, Miss, may I please open the debate, and then I would like to give the floor to Anna, if you don't mind, or I can do it as well, Anna, to explain the UNIDROIT enforcement project. Would you like to go first, maybe, Anna? So please, if I may give the floor. Okay, is there any question previously? Okay, so let's start from the end, please, and then I will come back to you, please.
Matthias Stormer, KU Leuven. I have some doubts whether it makes sense to have uniform rules for digital assets and to treat them as a category. And just take the two most important examples that we have discussed here, crypto assets on the one hand, social media on the other hand. They don't have much in common, and especially from the perspective of enforcement, the problems are completely different. What's the problem with crypto assets? To trace them and to have access. Once you have access, you can sell them. There's no problem. They have a value, there is a market. It's perfectly possible to enforce once you have access. There are no specific problems in that respect with cryptocurrencies, etc. So it's the first stage which is different. With social media, it's exactly the opposite problem. Access is not a problem. They're open. If they have any value, it's precisely because people want to give them as much publicity as possible. There's no problem to trace them. There are contractual rights, basically, so access is possible over the provider, etc. But there the problem is it doesn't make sense to sell them. If a celebrity is not paying its debts and you want to get money, the stupidest thing to do would be to sell off the social profile. No, you should find an enforcement procedure by which you oblige them to continue to use it and to make as much profit as possible and then seize the proceeds. And so you must find a way in order to make sure that the proceeds do not go to the debtor, but that the proceeds go to the creditor, and that the asset itself continues to exist as long as possible. So exactly the opposite problem of the problem of cryptocurrencies. So at first sight, we need two sets of rules for these two types of assets instead of a uniform approach.
Thank you very much. And indeed, one of the questions that has been raised in your comment completely rightfully is access what we need? Is control what we need? We need to find or apply already existing enforcement mechanisms, such as, for instance, continue the exploitation, the commercial exploitation of that particular asset, as in a satellite, for example, a space asset. You continue the exploitation and you receive the proceed. So it's a very good point, because we are again opening this discussion of to which extent we already have the mechanism, and we have to apply in a very creative way to the new realities. But this point about, absolutely, this point about making a distinction between certain categories of digital assets. Chef.
Yeah, with regard to access. Access is far more complicated, Matthias, than you presented. Access can be that you can only read but not write. It can be reading and writing, and so on. Access has very technical, very many levels. So a judicial enforcement officer can get something on a screen, and that already may be a problem, but that access may not be sufficient to sell it. So it's not that simple as you present it. That you have to distinguish different types of digital assets, we are in full agreement.
Thank you, Chef. Luis, any comment? Please.
I mean, I think the only thing well, there are two things to say. One is, it is obviously right that in some circumstances it's quite difficult to trace and find digital assets, but I would suggest that's true of other types of assets in the world. Anyone who's been a judge probably has come across other types of assets it's quite hard to find and trace if somebody makes an effort to hide them. So that's what we have, is rules to do with those, and maybe they need to be beefed up, but these are not digital asset specific rules. The other point I would say is something that Teresa said, which is that certainly the sort of digital assets that we're considering are very commonly held with custodians, and by those I would include exchanges as well. We have principles on those. I haven't gone through that, but we do that. And of course there you are in a position that is very similar to where any other asset is held through a custodian, and then you have, of course, you can find the custodian, and you need a procedure to be able to make an order against that custodian that they have to do certain things. That is not, again, a digital assets problem. That is, what are your rules about making orders against regulated or non-regulated entities? So if they're held in a custodian, then that is very different. I mean, the only situation where you could conceivably say you have a problem is where they're held by what we call self-custody, or held by directly by someone. And then there are different issues. Even then, I think one could get around them with ordinary rules. Thank you.
Thank you, Luis. Any comment, Dovile, Daria?
No. I just have a quick comment regarding the legal grounds for data processing. With respect to NFTs and social media profiles, I think it's quite similar. We just need to find a good legal ground to process data which has been gathered within the digital asset and connected with the digital asset, for example, regarding the holder of the asset. So in this respect, the situation, I would say, is quite similar. With other respects, I agree. However, in case of social media profiles, we have to remember that it is not only the access that we need, it is the photos or anything that has been published. What happens with that? We have to establish some common ground rules regarding intellectual property.
Thank you, Professor Medina Ortega.
On page 19 of the ELI principles that have been distributed to us, it is said that the novelty of digital assets makes it difficult to apply to them a classic property or contract law analysis. Of course, I, like you and many others, only have a classic property or contract law analysis. If a classic property or law analysis is not applied, what analysis can be applied? I say this at the moment when, for the last year, a lot of digital assets are in doubt. They have evaporated like smoke. When I talk to businessmen and economists, they say that digital assets is basically a fraud. And so the question is, I could be, if I were a businessman, I have a double accounting. On the one hand, accounting in real assets, mortgages, properties, and all that, and another accounting digital assets, so they could execute my digital assets and leave my house out of the possibly mortgage foreclosure. I don't know whether there is a solution for that, but this is what ELI principles are.
Well, absolutely, Luis.
I mean, I'm not sure I entirely understand your example, but if I do, I think certainly from the UNIDROIT perspective, we would be able to say something about that. So first of all, what we, I mean, I didn't write these principles. I'm not sure I agree. I mean, I think we would say that once you get to the stage where you say digital assets can be the subject of proprietary rights, then you can apply a proprietary analysis. Contractual analysis, well, I mean, you can make a contract about anything. I could make a contract about things that didn't exist. I could promise to, I don't know, sell you a Mickey Mouse. I mean, it wouldn't get you very far, but I mean, we could. So I don't think that contract comes into it. I mean, contract is contract. But in terms of property, one thing that I think you mentioned, which is something I think is very, very important, and I mentioned it, is this link between the digital asset, the token, if you like, and other assets. And I don't know if that's what you meant, but if that's what you meant, where you have a token that purports to be linked to land or to something else, then the only way that that link can be made is either through some very specific legislation or through other law, normal property law or normal law. And this is something that you cannot have harmonized law on this because it depends on individual countries' law, but it is something that I think needs a lot of analysis and thought, not from UNIDROIT or anywhere else, although we've given some examples, but from each jurisdiction, to say how does this actually work in practice? Because what is happening is that people are marketing these things as though they are linked to other assets, when in fact the legal link may not be effective. So in that sense, if that's what you meant, you are absolutely right, and I think this is something that needs attention, but it isn't something on which one could have harmonized law, because it would depend on the property law of each jurisdiction.
Thank you, Luis. Chef, please.
Just briefly, now first of all, I think what we should also distinguish here is, are we talking about procedural law or substantive law? Enforcement is mostly about procedure, and it touches, of course, upon substantive law questions. So you cannot enforce against a digital asset if you consider the digital asset to be nothing, right? So the two questions are linked, right? So that, and what I understand from, let's say, the UK project and the UNIDROIT project also is that it is commercial law oriented. The ELI project is broader. So it has a broader approach to digital assets. And in commercial law, when you have a security agreement, there is a different type of enforcement. When it comes to tokens and tokenization, we discussed that in the first installment of this project when it comes to security rights. Security rights. So can you use digital assets as security? And the problem was, what do you do with a token, for instance, if the token represents immovable property? If you sell the token, do you then sell the immovable property or not? And that is a very complicated question where there is no answer, where legal systems differ in their approach, where when you talk to property lawyers who are conservative by nature, they even don't want to talk about it because a token is not a notarial deed, is not a deed of transfer. Can it have an effect? There is no legal basis, and so on. So here, definitely, you need separate legislation. What we did is, we said the token should be seen separate from the asset. So in that project, we said nothing about the legal aspects of when you transfer the token, what do you do with regard to the immovable property? We kept away from that because that is too uncertain.
Yeah, and I agree, that's what we've done too.
Yeah.
Exactly right.
Thank you,
Yeah.
Chef. Just two additional comments, if I may, in relation to contract. Indeed, for example, an NFT, and I hope that you agree with me, NFTs indeed could be interpreted as a license agreement, as a contract, according to which the holder has certain rights in relation to, for instance, a digital masterpiece. Or stable coins might be analyzed from a contractual point of view between the issuer and the holders of these stable coins, for instance. So I don't know if you agree, but this idea of a contract as the basis for the emergence and the creation of digital assets is fundamental as well.
Well, the way we would look at it is to say you have two assets. You have the token and you have the contractual right. And whether the two are linked or not, as I've said, is a matter for other law. Exactly as Chef said. I mean, we are, I think, totally in alignment here. That's right.
Because indeed a token might be, for example, immovable property, might be simply a representation of the right, might be a traditio, might be therefore you have a contract, and by transferring the token, you are completing the traditio part for the selling of the immovable property, for instance.
But then that must be in the law. Right? There must be a clear rule. You cannot just say, well, we transfer by notarial deed. A token is on a blockchain. It looks like a notarial deed. So that is far too simple.
Exactly.
That, by the way, this is related to which extent the functional equivalence principle is enough to make this process of analogy and to say we're doing exactly the same, and therefore we don't need a specific acknowledgement by the law, or we need to create a legal framework that is more enabling in that regard. Thank you. I can see a question over there, please. Sorry.
Hello, I'm Sean Charlton from the Research Director of the ECJ. I've just, in relation to the UNIDROIT principles, are we not at risk of repeating some of the conceptual ambiguity that we, or importing it from more traditional property law? So just looking at the definition of a digital asset in relation to control, which is exclusivity, which is then more to do with ownership or the right of property, and then further on, we're saying that a digital asset can be the subject to security rights, and therefore they can be proprietary. So we're then adding third party to effect, almost going back to the definition of an asset. I was just wondering whether you have any thoughts on that.
Thank you, please.
Yes, sure. I mean, it's difficult to explain this without using the word possession. But I should say that we are not saying that digital assets can be possessed, okay? But control, we have the word, the concept of control does two things. First of all, it defines what we mean by a digital asset, because if it's capable of control, then it is something that is analogous, to use an analogy, to tangible property, although it's not tangible property, and therefore we would say it can be the subject of proprietary rights. Now, control does not mean the person in control does not necessarily own the asset. We make that absolutely clear. And if I lent my pen to Chef, he would not own my pen. I'd lend it to him to write something and then I can get it back. We would say I transferred possession. So control is functionally very similar to possession, but our concept of control is not the same as the legal concept of possession, largely, well, for two reasons. One is because it's a factual concept, and we don't have concepts of constructive control and something like that. And secondly, because possession has a large number of legal rules attached to it, and we don't want those all imported into control. But so when we talk about taking security, you can have proprietary rights over digital assets, therefore they can be subject to security. How you take that security and how you make it effective against third parties can be, one of our principles is you can do that by taking control. That is not a million miles from a pledge, where you just give possession of a tangible. But we are trying to get away from the vocabulary of possession, pledge, and all that kind of thing, to show that these are not tangibles and it is different.
Thank you, Louise. I have two questions, two hands raised, Anna and Pascal. Anna, please. We have 6 minutes to conclude, so I just wanted to have at least all the questions properly put forward, please.
Thank you very much. This is just to clarify one point and to give information, because there was a reference many times to UNIDROIT. Actually, as was said at the beginning, UNIDROIT has two very different projects, and they deal with different things, and they have a different scope of application, even regarding what they consider digital assets. And this because one of the projects is the one that was explained in more details by Louise, and even now with her answer, which is principles on digital assets with a restricted, in a way, definition of what is the scope of that, and where the most important thing is to give a notion of control and how you transfer and how you create, for example, a security right and effects as against third parties, but it does not purport to regulate the whole spectrum of what you can do with digital assets, and it expressly leaves a lot of issues to the famous other law, which is the national law, because it says no here. And the useful thing is that there is also a list of issues that national legislators might wish to look at and maybe to regulate, but they are not in the principles themselves. The other project, which is the enforcement project, is a general project on best practices for effective enforcement. So the enforcement on digital assets is very important, and that's why we dedicated quite a long discussions on that, and we are quite advanced in those discussions, but it's only a little part of a more general idea to give to offer best practices for extrajudicial and judicial enforcement. And one of the results of our discussion, because we wanted to be very practical, we were looking at, for example, case law, judicial case law on the enforcement on digital assets. Of course, judicial officers have much more information than that, but in the end it was quite difficult to pinpoint what were the issues that were really specific to enforcement on digital assets, except difficulties in practical terms. And probably one of them may be evaluation, but this is true also for other assets. So it's actually quite interesting now for us to see how to encompass this within the general. So I'll be very happy to then continue this discussion with you. But there, of course, we're looking at a wider spectrum. So sorry if I took so long, but I just was fearing that there might be some confusion. Thank you very much.
Thank you, Anna. And probably I can mention that in this UNIDROIT working group, what we are trying to focus is precisely on effectiveness. So to which extent enforcement is effective, including, for example, digital enforcement or enforcement in digital assets. So the effectiveness is key. Pascal, please.
Yes, thank you very much, Teresa. Just one point. We spoke about possession, proprietary rights, control, and in fact, terminology may be an unfaithful beauty. I think here one has to remember that it took us 100 years to distinguish possession from property in the civil perspective. And of course, when one begins to have tokenization of immovable under English law, things become even more, murky and difficult. That's why I think, for instance, when Louise speaks about proprietary rights, the term right or right in action is important, and the term proprietary might be a bit too excessive depending what type of asset you're looking at. Maybe you disagree, but and that's your right. But it depends also whether you have revalorous assets or non-revalorous assets that you want to enforce. And so indeed, I would be very careful to, and you are careful by saying it's not possession, it's control. But of course, we are all relating control to exclusive control, meaning property, which of course, implicitly, and we say, no, it's not property, but of course we have the same reflex. So I think here it's very dangerous, and the discussion we had here showed that indeed it is an unfaithful beauty here. I just wanted to make this reflection because it seems important to me.
Thank you, absolutely. Indeed, I was thinking that we have a couple of minutes to conclude, so may I give the floor to Louise, Chef, and Darian Dovile, so we can conclude the panel. So you can take the opportunity.
Well, thank you. I just wanted to say one thing to Pascal, which was that the phrase proprietary rights was that suggested by the civil lawyers. If we'd been common lawyers, we'd have talked about proprietary interests, but we were told that was an absolute no-no. So we said capable of, able to be subject to proprietary rights. So we don't mean a right in action, we mean a property right, or I'd call it a property right. So I think the terminology, I agree, is difficult, but we are guided in that respect by our civil law members of the working group. It's not a common law phrase. I would just say one other thing, I think, which is that what we're trying to do, and I think that may be a bit different from your project, is that we are trying to be as technologically neutral as we can, which means that we are really not very specific when we talk about private. We don't talk about private keys or blockchain. We give examples, but we are trying to be completely technology neutral. It is really, really hard. And it may be that we're not succeeding. And I think maybe your project is meant to be more specific and therefore more technologically specific.
Thank you, Louise. Chef?
Yeah. Just briefly again on terminology also. It reminds me of the debate on data ownership. In fact, it's absolutely clear that ownership of data is not the same as ownership of your car.
Yes.
Right? So, but the difficulty is that once when the term is used, you're stuck with the term. And you have to understand that it is used in a particular context, so with a particular meaning, which means that commentaries under principles, when terms are used, are of vital importance because the commentary explains. And so principles should be read, no, must be read in light of the commentary.
Thank you, Chef. Daria, please.
Yes, I will not be original when I say that I have one small comment on terminology as well. And that we just need to consider what exactly are digital assets, how should we treat them, whether they are intellectual property or any kind of different property, and whether they encompass or not personal data.
So if we are trying to make enforcement effective, so without the principles and without possibility to seizure this kind of assets, is no way. So we are now like practitioners lost and would like to get some guidance that to make debt enforcement more efficient. So we rely on you. Thank you.
Thank you very much. So thank you very much, all of you, for contributing to this enticing topic, this excellent panel. I am sure that this debate is fundamental, even if the crypto winter lasts. We know that this discussion on digital assets is critical because we're going to have NFTs, we are going to have a digital asset related to the growth of the metaverses that is going to happen immediately and is already happening as well. We're going to have digital assets that are simply rights embedded in digital representation. So it's a debate that is not purely topical. It's not just a debate of very fashion. It's something that is going to be part of the growth of the economic activity in the following year, the following debate. So this kind of debate, even arriving to the applicability of existing rules, can be preserved. Even there, this discussion, this debate is absolutely fundamental. So thank you very much for contributing to it. Thank you. Thank you.